From the IP that matters to foreign investors, India recognizes patents, trademarks, copyrights, designs, and semiconductor layouts. India offers a broadly robust IP protection framework, one that is aligned with international standards and backed by courts that are genuinely willing to grant effective interim relief. In India, IP protection is time-sensitive. The longer you wait to secure your rights, the more vulnerable you become. Hello and welcome back to the Veyrah Law series. Today's topic is something that any technology or brand-focused foreign business entering India would be concerned about: intellectual property and how to protect it. Whether you're a technology company, a pharmaceutical business, a consumer brand, or a manufacturer with proprietary designs, your IP is likely among your most valuable assets. Understanding how India protects those assets and what the practical realities look like on the ground is essential before you commit to the Indian market. My name is Ajay Joseph. I'm a partner at Veyrah Law. We are a law firm based in Mumbai, India. You can find more information about me and Veyrah Law on our website. The link is in the description below. Before we get started, a quick reminder. These videos are not advertisements or solicitations. They are only for sharing information. Nothing shared here should be treated as legal advice. Please consult specialist subject matter experts on this topic before making any decisions. Lastly, please read the disclaimers carefully. With that done, let us get into today's topic. Let us start with where India sits in the international IP landscape. India is a member of the World Intellectual Property Organization, WIPO, and is a party to the key international IP treaties. These include the Paris Convention for the Protection of Industrial Property and the Berne Convention for the Protection of Literary and Artistic Works, both administered by WIPO. India is also a founding member of the World Trade Organization and is bound by the Agreement on Trade-Related Aspects of Intellectual Property Rights, known as TRIPS. Because India is bound by TRIPS, it must provide at least the minimum standards of IP protection that TRIPS requires. And in broad terms, India's IP laws are aligned with those international standards. But India does operate with its own distinct nuances in certain areas. Two are worth flagging at the outset because they have real implications for foreign businesses. First, software is not patentable in India. Unlike the United States, where software patents have been routinely granted, Indian patent law excludes computer programs per se from patentability. Certain computer-related inventions that produce a technical effect can still be patented, but pure software code is not patentable. It is instead protected under copyright law as literary work. Technology companies need to understand this before structuring their IP strategy for India. The second, India has a uniquely restrictive approach to pharmaceutical patents. Indian patent law limits patents on new forms of known substances unless the applicant can show enhancement of known therapeutic efficacy. This provision was specifically designed to prevent evergreening, where drug companies try to extend patent life through incremental modifications. It led to one of India's most significant IP cases. In Novartis AG versus Union of India, the Supreme Court upheld this restriction and refused a patent for a modified form of the cancer drug imatinib because enhanced efficacy was not established. This judgment has had far-reaching implications for how the global pharmaceutical industry approaches India. With that context set, let us work through the IP protection available under Indian law. In broad terms, from the IP that matters to foreign investors, India recognizes patents, trademarks, copyrights, designs, and semiconductor layouts. The table sets out the broad timelines of protection for the important IP. Now let's look at some details around each of these intellectual property elements. Firstly, patents. Patents in India are governed by the Patents Act 1970, which was significantly amended in 2005 to bring India's patent law in line with its TRIPS obligations. A patent gives the holder an exclusive right to manufacture, use, sell, or import the patented invention for 20 years from the date of filing. Beyond the software and pharma nuances already discussed, one more area to be aware of is India's compulsory licensing regime. Under this, a third party can apply to the controller of patents for a license to use a patented invention without the patent holder's consent in certain circumstances. This includes situations where the patented product is not available at a reasonably affordable price. India has used this provision most notably in the Natco-Bayer case, and it remains a live risk for foreign patent holders, particularly in pharma and technology. Next, trademarks. Trademarks in India are governed by the Trademarks Act 1999. A registered trademark gives the owner an exclusive right to use the mark for the goods or services it covers, and to take action against unauthorized use. Registration is valid for 10 years from the date of application and may be renewed indefinitely. India follows a first-to-use system alongside registration, meaning unregistered marks can still be protected on the basis of prior use and reputation through the common law action of passing off. India also recognizes well-known marks with a high level of public recognition and gives them broader protection beyond the specific goods or services they are registered for. One practical note: trademark squatting is a real and documented problem in India. Third parties sometimes register well-known foreign marks before the legitimate owner enters the market. File early before you start operating in India. Next, we have copyright. Copyright in India is governed by the Copyright Act 1957. Protection is automatic. It arises from the moment of creation and does not require registration. That said, registration is advisable because it creates a public record and provides evidentiary advantages if you ever need to enforce your rights. The duration of the protection is the author's lifetime plus 60 years. As mentioned, software is protected as a literary work under Indian copyright law, making copyright the primary form of IP protection for software in India. One nuance that surprises many international businesses: Indian copyright law recognizes moral rights. These include the right to claim authorship and the right to object to any distortion or modification that is prejudicial to the author's honor or reputation. India is a member of the Berne Convention, so copyright works created in India are automatically protected in all other Berne member countries, and vice versa. Next, we have designs. Design protection in India is governed by the Designs Act 2000. It protects the visual or aesthetic appearance of a product, its shape, configuration, pattern, or ornamentation, as applied to an article by an industrial process. It does not protect functional features, only visual appearance. The initial protection period is 10 years from registration, extendable by a further 5 years. One important limitation to note: if a design is registered under the Designs Act, it cannot simultaneously be protected as a copyright artistic work in relation to the same article. And even if it is unregistered but capable of being registered, the copyright in that design ceases once it has been applied industrially more than 50 times. This intersection between design and copyright law is an area where specialist advice is particularly important. Then we have semiconductor integrated circuits, layout designs. For businesses in the semiconductor and electronic space, India has a dedicated statute, the Semiconductor Integrated Circuits Layout Design Act 2000. This act protects the original topography or layout design of integrated circuits. Protection lasts for 10 years from the registration filing date or from the date of first commercial exploitation. whichever is earlier. This is a specialized area, and businesses in the semiconductor space should engage advisors with specific expertise. Now, having looked at what protections are available, let us turn to perhaps the most important question for foreign investors. How effectively are these rights enforced in India in practice? IP enforcement in India has a genuinely encouraging story to tell, and it is one that surprises many foreign investors who assume, based on India's broader reputation for judicial delay, that IP rights would be just as difficult to enforce. The reality in this domain is more favorable. India's courts, particularly the high courts in Delhi, Mumbai, Bengaluru, Chennai, and Kolkata, have consistently shown a willingness to grant interim relief in IP matters quickly and effectively. Interim injunctions, orders restraining an infringer from continuing the infringing activity while the case is pending, are routinely granted, where the right holder can establish a prima facie case, show that the balance of convenience is in their favor, and demonstrate that not granting relief would cause irreparable harm. This three-part test is well established in Indian jurisprudence. Penalties for IP violations are also meaningful. Under the Trademarks Act, criminal liability can result in imprisonment of up to 3 years and fines. Copyright infringement also carries criminal penalties. Civil remedies include damages, account of profits, and delivery of infringing goods for destruction. The challenge, as with most litigation in India, lies in the long-term outcome. Full trials and final judgments can take years. But here is the critical distinction in IP cases. Interim relief is often the victory, an injunction that stops an infringer from selling counterfeit goods or using your mark is, commercially speaking, exactly the outcome that matters. It stops the harm. And once interim relief is obtained, parties almost always move toward a negotiated settlement rather than pressing on to a full trial. This makes IP one of the areas where the Indian judicial system, despite its broader challenges, actually delivers reasonably effective protection. Piracy and counterfeiting remain real concerns in India, particularly in software, luxury goods, pharmaceuticals, and media. But legitimate IP owners who are well advised and act promptly have real and effective tools available to them. With that picture in mind, let us turn to what investors should do in practice. Here are the key principles we share with clients on IP strategy in India. First, engage specialist IP advisors early. IP law in India is a specialized domain. A full-service law firm can provide general IP counsel, but for detailed technical work, particularly patent drafting and prosecution, you need advisors with deep expertise in the relevant field. Patent claims must be drafted with precision. Errors at the drafting stage can fundamentally weaken your patent scope of protection. Second, file before you enter the market. This cannot be overstated. File your trademark, patent, and design applications before you begin operating in India. India's trademark system recognizes first-to-use rights, but registration is far stronger and much easier to enforce. Trademark squatting is a real and documented problem. The cost of securing registrations before market entry is a fraction of the cost of litigating to reclaim your mark after a third party has secured registration over it. Third, use interim relief as your primary enforcement strategy. Indian courts are generally responsive to well-founded interim injunction applications in IP matters. If you identify infringement, act promptly. Delay can be construed as implied consent, and it weakens your case. Move quickly and build a strong application for interim relief. Do not wait for a comprehensive investigation before approaching the court. The interim order is your commercial victory. Once you have it, the rest can be negotiated. Fourth, use criminal remedies strategically. Criminal complaints under trademark and copyright law can be powerful tools. not necessarily because a conviction will follow quickly, but because the process itself creates real pressure on infringers. Police raids on premises selling or manufacturing counterfeit goods and the publicity it creates are highly effective deterrents. Use criminal remedies strategically alongside your civil enforcement proceedings. Fifth, understand the software patent gap and plan around it. If your business depends on proprietary software or algorithms, know from the outset that Indian law will not give you patent protection for those assets. Your IP strategy must rely on copyright, trade secrets, contractual confidentiality, and access controls. Structure your technology licensing agreements carefully. Where possible, retain the underlying source code and know-how outside India, and grant only the operational access necessary for your Indian operations. Sixth, Tier 1 cities offer the best enforcement environment. If enforcement matters to your business, and for technology, pharma, media, and consumer brands, it usually does, ensure your registered office and operational base are in a Tier 1 city. IP enforcement in Tier 2 cities and smaller towns is considerably more challenging in practical terms. To summarize, India offers a broadly robust IP protection framework, one that is aligned with international standards and backed by courts that are genuinely willing to grant effective interim relief. The nuances, no software patents, the pharma evergreening restriction, the compulsory licensing regime are real. They need to be understood before you enter the Indian market. But they are all navigable with the right specialist advice. Piracy and counterfeiting remain concerns, but legitimate IP owners were well advised, file early and act promptly when infringement occurs can protect their rights effectively, particularly in Tier 1 cities where the enforcement infrastructure is strongest. The most important thing to take away about IP enforcement in India is this. Unlike commercial contract disputes, where judicial delays make enforcement slow and painful, IP is an area where Indian courts move with considerably more urgency. Interim relief is available, effective, and routinely granted. It is the commercial outcome that matters, and India delivers it. In India, IP protection is time-sensitive. The longer you wait to secure your rights, the more vulnerable you become. We hope this episode has given you a useful overview of IP protection in India. If you found this video useful, please do share it with others who may benefit. Thank you for watching and see you in the next episode.